I wasn't invited to my own granddaughter's first birthday. My son-in-law looked me in the eye and said, "You smell like old age." I said nothing, but exactly 2 days later he called, asking for $20,000. I answered with just one question, and it changed everything. He had no idea that an old man's silence can be the most expensive thing in the world. Before continuing, subscribe to the channel and write in the comments what time it is in your region right now. The sander went quiet the moment I heard her voice. I'd been standing in my garage workshop since 7 that morning, running a sheet of 220 grit across the surface of an oak dresser I'd been building for my neighbor Frank. The grain was coming in beautifully, deep amber lines that looked almost like brush strokes when the morning light hit them at the right angle. Woodworking does that to me. It quiets everything down to the sound of the tool, the smell of fresh sawdust, the feeling of something raw becoming something solid and honest. I'm Walter Bishop, 67 years old, retired after 32 years managing real estate loan portfolios for First Tennessee Bank in Brentwood. I know how to read documents. I know how to be patient. And I know, with a certainty that comes from reading 10,000 loan files, when the numbers don't add up. My daughter Sarah called at 10:30. The moment I heard that particular lightness in her voice, the one that's not quite cheerful, the one she uses when she's carefully managing a situation rather than actually living in one, I set down the sander and gave her my full attention. "Hey, Dad. Hey, sweetheart. I saw the photos." A half-second pause, just long enough to be a tell. "Oh, yeah, the party was really nice. Lily loved the cake. You know how she gets with sugar. She was running around for like an hour after it was—" "Sarah," I kept my voice level and quiet. "Her birthday was yesterday. I found out this morning when Instagram decided to show me your post. There are certain kinds of silence that carry more information than words. The one that came through the phone just then was the kind a person produces when they know they're standing in the middle of something they helped construct. My daughter, 34 years old, bright when she chooses to be, and considerably more malleable than she should be, started doing what she always does. When a conversation makes her uncomfortable, she began moving sideways. "Dad, it wasn't— Lily gets overwhelmed with too many people. She's only one. And we wanted to keep it small. And honestly, it went so fast, I barely had time to even think about— Who was there?" Another pause, shorter this time, which meant she'd been expecting this question. "Kyle's parents, and a few of our friends." Kyle's parents. Not a small gathering then. A selected gathering. I've been a father for 34 years. I sat in hospital waiting rooms and drove carpool in the rain. I built the bunk bed in Sarah's childhood bedroom entirely by hand. The one with the little ladder that squeaked on the third rung and that she refused to let me fix because she liked the sound of it. I was there for every fever, every school play, every tearful phone call after a bad breakup in her 20s. I watched Kyle Fletcher walk into my daughter's life 6 years ago with his confident handshake and his polished financial consultant's vocabulary, and I gave him the benefit of every doubt I possessed. That is what you do. You step back. You let your daughter build the life she chooses. But standing in my workshop that morning, I understood something had shifted. The exclusion had been deliberate. I had been left out on purpose, and my daughter was now asking me to accept a soft explanation in place of a real one. "Can I speak to Kyle?" I asked. Sarah went quiet again. That specific kind of quiet that means she already knows what's coming and is bracing herself for it. I heard muffled movement, a door closing in the background, and then Kyle's voice came on the line. Relaxed, unhurried, the voice of a man who believes he's the only one at the table who has been paying attention. "Walter." Not Dad. Never Dad. Not even after 6 years of marriage to my daughter. Just my first name, delivered the way you'd address a colleague you tolerate at a quarterly meeting. "Kyle, I was asking Sarah why I wasn't at Lily's birthday party." "Yeah." A short exhale through his nose. Almost a laugh, but not quite bothering to become one. "Look, I'll be straight with you. Honestly, you smell like old age, Walter. Lily's 1 year old. She doesn't need some gloomy grandfather hovering over her." I stood very still. 32 years of reviewing loan applications sharpens one instinct above all others: The first thing a person says is almost never the most important thing. The important thing comes after, once they think you've already absorbed the blow. I filed Kyle's words away the way I'd once filed problem loans. Methodical, without reaction. I didn't shout. I didn't argue. I didn't give him the satisfaction of a reaction he could observe and measure and feel pleased about later. Understood, I said, and I ended the call. I sat down on the low wooden stool near my workbench. The oak dresser stood before me, half finished, its surface warm and honest in a way that wood reliably is, and people frequently are not. I looked at it for a long time without touching it, thought about my granddaughter Lily, who was now officially 1 year old, and whose birthday party I had not been invited to. Thought about the photo I'd seen that morning, Sarah's Instagram post, the little girl in a party hat reaching toward a smear of frosting on her tray, surrounded by people I mostly recognized, and one I was not. My son-in-law had told me I smelled like old age. He had said it without hesitation, without lowering his voice, with the casual confidence of a man who had been thinking it for some time, and had simply decided there was no longer a reason to keep it to himself. I picked up the sander, turned it back on, let the sound fill the garage. 3 minutes later, the phone lit up on the workbench beside me. Kyle's number. I watched it ring. I let it go. He called again 12 minutes later. Then a third time, 40 minutes after that. I didn't answer any of them. By the time evening settled over the neighborhood, I'd finished sanding the dresser, applied a first coat of Danish oil, cleaned the brushes, and swept the workshop floor. The garage smelled like linseed and oak. I stood in the doorway for a moment before going inside, looking at the dresser under the overhead light. Solid, predictable, exactly what it was supposed to be. The voicemails from Kyle sat unplayed on my phone all evening. Late that night, I felt it buzz with a text notification. 7 words, no punctuation. "We need $20,000. Can you transfer it?" I read it twice, set the phone down, poured a glass of water, came back and read it a third time, because some things deserve 3 chances to mean something different than what they obviously mean on the first reading. This one didn't take the opportunity. I thought about the man who had told me, less than 12 hours earlier, that I smelled like old age and had no place at my granddaughter's birthday. And I thought about how that exact same man was now asking me to move $20,000 before I'd had time to finish processing what he'd said. The confidence required for that particular sequence, insult first, request 12 hours later, is not the confidence of someone who respects you. It is the confidence of someone who has learned, through repetition, that you will absorb the insult and produce the money regardless. I went to bed, didn't sleep much. I thought about a summer afternoon 8 years back, before Kyle was in the picture, when Sarah had driven down from Nashville just to spend the weekend. No occasion, no reason. She'd sat at my kitchen table Saturday morning while I made coffee, still in her pajamas, telling me about a problem at work. I'd offered a few observations. She'd laughed at one of them and said, "Dad, how are you always this calm about everything?" I'd told her it wasn't calm exactly. It was knowing the difference between problems that needed immediate action and problems that needed patience and information first. She'd nodded slowly. "That's actually really useful," Kyle proposed to her 4 months later. And gradually that girl who drove 3 hours for no particular reason became someone I needed to schedule 2 weeks in advance to see for 45 minutes. The next morning I called Kyle back. He picked up on the second ring. The warmth was back immediately. The practiced warmth of a man who knows which register to use when he needs something. A consulting client had delayed payment on a contract. An account needed settling by Tuesday, entirely temporary. He'd have it back within the month. Smooth enough, specific enough to sound real, vague enough to resist verification. When he finished, I let a few seconds pass. "Did I not notify you?" I said. "What? Did I not make my position clear yesterday?" A short silence, the sound of a man recalculating. I hung up. He called back within 4 minutes. I didn't answer. I got dressed, drove to the Brentwood Public Library on Concord Road, found an open terminal at the back of the reference section, and sat down. Tennessee maintains a public civil court records database that any resident can access at no cost. You put in a name and see what comes back. I had used systems exactly like this for 32 years, as a routine part of loan evaluation, checking whether someone's financial story matched the public record. It took me less than 3 minutes to find what I was looking for. Kyle Fletcher, Williamson County. First result, a civil judgment filed the previous year. Creditor, Marcus Webb, former business partner. Amount, $43,800. Status, unsatisfied. Still open. I sat back in the library chair. I thought about a Sunday dinner 4 years earlier. Kyle had stood on my back porch describing a business venture he was building with a partner. Energized, detailed, convincing. I'd asked questions. He'd answered them fluently. I remembered thinking, sharp. Maybe too polished, but sharp. What I hadn't known was that the same venture had ended with a $43,800 judgment against him, filed 14 months later. Still unpaid. I kept searching. 2 active collection accounts surfaced in associated records. Not small ones. The kind that accumulate through a sustained pattern. Spending above income, bridging the gap with borrowed patients and other people's money. I wrote the case numbers on a notepad. Old habit. I don't trust screens with things I actually need to keep. Then I sat quietly for a while. I thought about my daughter, the earlier version, the one who called me Sunday mornings from college just to talk. The one who stood in my kitchen the first time she brought Kyle home, nervous in the specific way daughters are when introducing someone they love to someone whose opinion still matters. I had shaken his hand and meant the warmth behind it. I had genuinely wanted to like him. And now I was sitting in a public library, looking at $43,800 in unpaid judgments under his name, while he waited somewhere across town for me to wire him $20,000 by Tuesday. A man in financial trouble reaches for whatever is closest. I understood that part. What I was understanding now, with the particular clarity that comes from seeing something in a court record rather than merely suspecting it, was that Kyle hadn't reached for me out of desperation. He had reached for me because he had decided I was available for reaching, not a person with standing of my own, a resource, a line item, something to be kept at a convenient distance and accessed when needed. He had told me I smelled like old age. 12 hours later, he'd asked me for $20,000. I closed the browser, cleared the history, folded the notepad into my jacket pocket, and walked back to my car slowly, the way I do when I'm thinking through something that requires precision. I sat in the driver's seat without starting the engine. 67 years old, a paid-off house, a workshop full of tools I know how to use, and 3 decades of understanding exactly how financial trouble works, and what it looks like when someone is working hard to keep you from seeing it clearly. I started the car. The deeper you dig into someone's finances, the more their actual character comes into focus. I spent the better part of the next several days back at the library terminal, working through public records the way I used to work through loan files. Systematically, without rushing, following each thread to where it ended before picking up the next one. I wasn't looking for drama, I was looking for pattern. In my experience, pattern is always more telling than any single event. What I found confirmed that Kyle Fletcher's request for $20,000 was not a temporary inconvenience. It was a symptom. The civil judgment for $43,800 had been filed by Marcus Webb, a man who had partnered with Kyle in a short-lived financial consulting LLC that dissolved in under 2 years. The court filing described a dispute over client funds, specifically fees that had been collected from mutual clients, but never deposited into the business account. Marcus Webb had sued to recover his share of those fees. The judgment in his favor had been entered 11 months before Kyle called me asking for $20,000. 11 months, and not a dollar of it had been paid down. The 2 collection accounts in the public record were smaller individually. One for $4,200 owed to a property management company, one for $6,650 owed to a contractor. But they painted the same picture. Kyle Fletcher was a man who received money, spent it on something other than what it was intended for, and then managed the fallout by borrowing time and goodwill from whoever was closest and most likely to give it. I wrote all of it down in my notepad with careful, even handwriting. Case numbers, creditor names, amounts, filing dates. When I was done, I sat and looked at what I'd written for a long time. Several days after my library visits, Sarah called. I was in the workshop when the phone rang, sanding the underside of a drawer for Frank's dresser, which I'd been slower to finish than usual because my mind kept pulling elsewhere. I set down the sandpaper and answered. Dad. Her voice had the practiced evenness of someone who'd rehearsed the opening. You haven't been returning Kyle's calls? He says you're upset about something small, and you're making it into a bigger deal than it needs to be. I let that sit for a moment. Something small. Sarah, I said, does Kyle know I've been looking at the public court records for Williamson County? A brief pause. What? I'm asking whether he mentioned that to you. No. Why are you looking at court records? I hadn't planned to say it quite yet, but sometimes a question arrives at exactly the right moment, and the answer it deserves is a direct one. Because your husband has an unpaid civil judgment against him for $43,800, I said, filed by his former business partner, plus 2 collection accounts in the public record totaling just over $10,000. That's not a client delaying a payment, sweetheart. That's a pattern. The silence that followed was longer than any that had come before in our recent conversations. Not the calculated silence of someone managing their response. Something rawer than that. Then very quietly, 43,000. What? Where did you? And in the background, closer than she probably realized, I heard Kyle's voice. Who was that? Sarah's tone shifted immediately, the small automatic adjustment that I'd been noticing for years but only now fully recognized for what it was. Nobody. It's my dad. Just a minute. What does he want? Nothing, Kyle. Sarah. His voice sharpened. Not a question, an instruction. I have to go, Dad, she said quickly. I'll call you back. She didn't call back, not that day and not the next. What arrived instead, 2 days later, was a letter. Ramsey and Polk, LLC. Attorneys at Law, Nashville, Tennessee. The letterhead was doing its best to look important. I read it standing at the kitchen counter. The substance, in the calendar year 2 years prior, I had allegedly borrowed $8,500 in cash from Kyle Fletcher for emergency roof repairs. Failure to remit $8,500 plus $340 in accrued interest within 14 days would result in a claim filed in Williamson County General Sessions Court. No promissory note referenced, no check number, no wire transfer, no signed acknowledgement, no date more specific than the year. Just the assertion itself, printed on letterhead and dressed in formal language designed to feel weightier than it was. In Tennessee General Sessions Court, the small claims limit is $25,000. Kyle's attorney had filed a letter threatening action over an amount that, if it went to hearing, would be decided in a single session with no requirement for legal representation. The strategy was transparent, look official enough that I'd write a check to avoid the hassle. I set the letter on the kitchen table, went to the workshop, picked up the sandpaper, finished the drawer. Then I went back inside and read the letter one more time, this time with a legal pad beside me and a pen in my hand, making notes in the margin. I had the contractor's invoice from that roof repair. I had the check I'd written, from my own account, in an amount matching the invoice exactly. I had the bank statement. I had everything except a reason to be nervous, which was almost certainly the point. Kyle was counting on me not having kept records. He'd miscalculated on both counts. I folded the letter, put it in the drawer with my other documents, and went to bed earlier than usual. The next move was going to require some professional assistance, and I already knew exactly where to start. The office at 154th Avenue North was on the 5th floor of a building that smelled like carpet cleaner and old coffee. The combination that means a place has been professionally maintained by people who care about function more than atmosphere. I appreciated that. A lawyer's office that smells like a spa makes me nervous. Raymond Garza's name was on a placard beside the door at the end of the hall. Attorney at law, estate planning, property law, trust administration. I'd found him through the Tennessee Bar Association's online directory. 31 years in practice, strong client reviews, clean disciplinary record. I'd called 3 days after receiving the Ramsey and Polk letter and been given an appointment for the following week. He was a compact man in his mid-50s, with reading glasses pushed up on his forehead, and the particular calm of someone who has heard a great many complicated family situations and stopped being surprised by any of them. He gestured to the chair across from his desk and waited while I settled in. I laid it out for him methodically. The birthday party, the phone call, the $20,000 request, the library research, the $43,800 judgment, the 2 collection accounts, the business dissolution, the letter from Ramsey and Polk claiming I owed Kyle $8,500 for a loan I had never received. I kept my voice level throughout and watched his expression, which remained carefully neutral, in the way experienced professionals maintain when they're actually paying close attention. When I finished, he was quiet for a moment. "You have documentation for the roof repair?" he asked. "Invoice, canceled check, and bank statement." "Good." He made a note. "Do you have a will?" "From 6 years ago. It names my daughter as primary beneficiary. The house, the retirement accounts, everything." He looked up from his notepad. "Does your son-in-law know the contents of that will?" I thought about it. "Sarah knows. I'd assume she mentioned it to Kyle at some point." Garza nodded slowly, in the way people do when a thing they suspected has just been confirmed. He reached to the side of his desk and withdrew a printed form. Several pages, stapled, set it in front of me. "This is a revocable living trust," he said. "In Tennessee, property held in a living trust doesn't go through probate. It transfers directly to whoever you designate, without a court process, without public record, and without anyone having the opportunity to contest it the way they can contest a will. If someone were planning to challenge your estate based on an alleged financial obligation, a will gives them a point of entry. A properly structured trust makes that considerably harder." "How long does it take?" 2 to 3 weeks for full documentation. We'd draft an updated power of attorney and healthcare directive at the same time. He set down his pen. "The full package, trust, POA, directive, and property deed transfer, is $2,900. "And the letter from Ramsey and Polk?" He read it in about 40 seconds and set it back down. "I'll request documentation of the alleged loan, proof of the cash transfer, written acknowledgement from you, anything establishing the transaction occurred." A dry, small smile. "They won't produce any." "The letter will stop." I wrote him a check for $2,900 on the spot, and we scheduled the follow-up appointment to sign the trust documents. On the way out, I stopped in the lobby to button my coat. Garza had given me the defensive foundation I needed. The trust would protect the house. The Ramsey and Polk response would close that door. But those were protective moves, walls, not forward ground. I was still thinking about that when my phone buzzed in my coat pocket. A text from Sarah. Not a call, a text, which meant Kyle was likely nearby. "Dad, Kyle says if you don't help us, we're going to lose the car. Do you really want Lily riding to daycare in a taxi?" I read it in the lobby of a law office where I had just spent $2,900 to protect my estate from the man who had written that message's instructions. I put the phone in my pocket without answering. Outside, I walked to my car and sat in the driver's seat for a long moment, watching the street. The oak dresser in my workshop was finished, Danish oiled, ready to deliver. Frank would be pleased with it. The grain had come out exactly right. I thought about what Garza had said about the trust, about how a properly structured document changes what other people can and cannot do with your assets. Not through confrontation, but through quiet, legal precision, through the kind of preparation that looks like nothing from the outside until it becomes everything. Kyle had sent his mother's lawyer after me with a fabricated debt. He'd had someone photograph my house. He was now using my daughter and my granddaughter as leverage to extract money he had no legitimate claim to. He thought I was reacting. He thought I was a man who would absorb pressure and eventually produce a check because it was easier than the alternative. I started the car. Kyle thought I was reacting. He thought I was the kind of man who absorbs pressure and eventually writes a check because it's easier than the alternative. He was about to learn the difference between a man who avoids conflict and a man who simply prefers to choose his ground first. I had my lawyer, I had my documents, and I had a growing certainty, clear and quiet, the kind that arrives through work rather than emotion, that the $43,800 judgment and the 2 collection accounts were not the end of what there was to find. They were the beginning. I read Sarah's text a second time in the car outside Garza's building. "Dad, Kyle says if you don't help us, we're going to lose the car. Do you really want Lily riding to daycare in a taxi?" I noticed the phrasing, not "we think" or "we're worried about," Kyle says, as if he'd written the script and handed it to her, and she delivered it without reading it carefully enough to notice how it sounded. My granddaughter Lily, 14 months old, unaware that she was currently being used as a rhetorical device, probably had more authentic communication skills than the 2 adults managing her schedule. I called Sarah back. She picked up on the second ring. "Dad, I'm not upset, Sarah. I just have a few questions." A pause, and I could almost hear her recalibrating. When I don't sound angry, it apparently worries her more than when I do. "Okay. How much is your townhouse rent?" "What does that have to do with humor me? Monthly rent." A longer pause. $2,400. "Right. And Kyle's salary is $74,000 a year. After federal and state taxes in Tennessee, that comes out to roughly $54,000 take home. Minus rent, that's $28,800 left for the year. Minus the car payment, the daycare, which I know is around $1,100 a month based on what you mentioned last spring. Groceries, utilities. You're at approximately zero by year end, before the $43,800 judgment." I let that settle for a moment. "So I'm asking you directly, where does the money go, Sarah?" The silence that followed was different from the managed ones she'd been producing lately. This one had weight to it. The weight of a person standing in a room they've been carefully not looking at, and suddenly the lights are on. Then quietly, "You're watching us." "I'm reading public records. Tennessee posts civil court judgments online. Anyone in the state can look them up. It's free and it takes about 3 minutes. I kept my voice even. "I'm not surveilling your family. I'm trying to understand why your husband has asked me for $20,000 and simultaneously sent a lawyer's letter claiming I owe him $8,500 I've never borrowed." A longer silence, and then faintly, from somewhere close to wherever Sarah was standing, Kyle's voice. Not words I could make out, just the tone, the particular sharp undertone that means stop talking. Sarah said, "I have to go," and ended the call. 4 minutes later, a text arrived. Not from Sarah, from Kyle's number, which I hadn't saved under a name but recognized immediately. "Old man, don't make a mistake you can't undo." I took a screenshot. The timestamp, the number, the message, all of it visible in a single frame. Saved it to the folder on my phone I'd been using for documentation since the library visit. Then I put the phone in my jacket pocket, started the car, and drove home. I want to be precise about how I felt in that moment. Not frightened, not particularly angry. What I felt was the quiet, focused attention that arrives when an ambiguous situation becomes clear. Kyle had just sent a written threat from his own phone number to mine. Whether he understood he'd handed me a documented piece of his own conduct, I couldn't say. But he had, and I had saved it. Back home, I went to the workshop. Frank's dresser was long finished and delivered, but the workshop is where I think clearly. I stood at the bench and considered the shape of what I had. The public records, the Garza documents, the screenshots, the contractor invoice that disproved the $8,500 claim. I thought about the shape of Kyle's strategy. The fake debt was an opening move, designed to extract money or create a nuisance. The emotional appeal through Sarah was a parallel track. The threat was what people send when the first 2 tracks aren't producing results, and impatience is setting in. Impatient people make unforced errors. 3 days passed without direct contact from either Kyle or Sarah. I used the time well. I went back to the library once more, checking for any additional public records I might have missed. I also pulled the property tax records for the townhouse on Carruthers Parkway, which confirmed that Kyle and Sarah were renting, not purchasing, and that the lease was in Kyle's name only. That detail went in the notepad. On the 3rd day, my neighbor Dorothy came over. She's 71, lives 2 houses down on Ridgecrest, and has the observational habits of someone who spent 30 years as a school principal. which is to say, nothing happens on this street without her noticing it. She'd come to return a level she'd borrowed to hang a mirror, and while she was at the door, she mentioned, with the particular careful casualness of someone who knows they're about to say something important, that she'd noticed a car parked on the street twice in the past week. "Dark blue," she said. "Kia, I think. Tennessee plates. It didn't park in front of anyone's house exactly. Kind of between yours and the Miller's." She paused. "The second time, someone got out for a few minutes. Had their phone out." "What did they look like?" I asked. "Woman, 60 or so, well-dressed, dark coat." Dorothy gave me a look that conveyed without words that she'd noticed more than she was saying, and would say the rest of it if I wanted to hear it. "Seemed like she was taking pictures of the front of your house." I thanked her and went inside. I wrote down everything Dorothy had described: the car, the approximate timing of both appearances, the description of the woman. Then I sat at the kitchen table and thought about it for a while. Kyle did not have a sister. His father had passed several years before. The woman Dorothy described, 60 or so, well-dressed, driving a Kia, matched exactly one person in my mental directory of people connected to Kyle Fletcher, his mother, Diana. I called Garza the next morning. Garza listened to the description of the car and the woman without interrupting. When I finished, he was quiet for a moment, the specific silence of a lawyer who has just connected a new piece of information to a theory he was already developing. "Does your son-in-law's mother know the contents of your current will?" he asked. "My daughter does. I'd assume it came up." "Your will names Sarah as primary beneficiary. The house, the accounts. A paid-off property in Brentwood, county assessed around $387,000. That's significant to someone sitting on $43,800 in unpaid judgments." He paused. "Photographing a property from a public sidewalk isn't illegal, but it's consistent with someone estimating asset value before a legal action, which is also consistent with the demand letter." Another pause. "Document it formally, not to use immediately, just to have." That afternoon, I hired a licensed private investigator, Davenport Investigations, on Church Street in Nashville. I found them through a straightforward internet search for licensed PI agencies in Davidson County, checked their credentials with the Tennessee Secretary of State's Business Registry, and called the same afternoon. The man I spoke with, who identified himself only as Davenport, had the professionally neutral manner of someone whose entire business depends on being thorough without being dramatic. I explained what I needed: documentation of any further appearances of the dark blue Kia Optima near my address, and identification of the registered owner. 1 week of observation. His rate was $1,800 flat. On the same day, I made a second call. The public records I'd accessed myself only showed part of Kyle's financial picture. The items that had reached formal court filings. What I needed was a clearer view of the full pattern: cash flow, spending behavior, obligations that hadn't yet crystallized into lawsuits. I found Tina Pavlovska through the Tennessee Society of CPA's referral directory for independent financial consultants. Her specialty, forensic financial analysis and litigation support. I called, confirmed the scope of what I needed, and scheduled a consultation. Her rate for an initial report was $900. While all of that was being put in motion, the week moved quietly. Kyle did not text again. Sarah did not call. The blue Kia did not reappear, at least not that I saw. But then I hadn't hired Davenport to watch what I could see from my own window. I'd hired him to document what happened when I wasn't watching. 7 days after I'd given him the assignment, Davenport emailed me a PDF. 6 pages, clean formatting, photographs attached. I read it at the kitchen table with a cup of coffee. The Kia Optima with the Tennessee plate I'd recorded was registered to a Diana Fletcher at an address in Hermitage, East Nashville. Age listed in the associated registration records, 61. The vehicle had been observed on Ridgecrest Lane twice during the surveillance period. On the first occasion, the registered owner had exited the vehicle, stood on the sidewalk adjacent to my property for approximately 4 minutes, and used a phone to photograph the front elevation of the house. On the second occasion, she had remained in the vehicle but had been observed using a phone, possibly also photographing the property. Both visits documented. timestamps, photographs of the vehicle with plates visible, photographs of the woman on the sidewalk during the first visit. I called Garza and read him the key points. Diana Fletcher, I said. Kyle's mother. 61 years old, Hermitage address. I heard him write something down. You have the investigator's report? In hand. Keep it. Don't do anything with it yet. He paused. How far along are we on the trust documents? Signing appointment is next week. Good. Once the trust is executed and the property deed is transferred, the house is no longer in your will. It's in the trust. If someone were planning to challenge your estate or make a claim against your assets based on an alleged debt, the legal landscape looks quite different after that transfer. Another pause, this one heavier. I think they're trying to understand what they're dealing with before they make their next move. The photographs tell me they're still in the planning stage. The question is what their plan actually is. I told him about the text from Kyle, the screenshot. A brief silence. Send me that. I forwarded it while we were still on the phone. He confirmed receipt. That may matter later, he said simply. After I hung up, I stood at the kitchen window for a while. The yard was ordinary in the late afternoon light. The oak by the fence, the path to the workshop, everything where it had always been. I thought about Diana Fletcher on my sidewalk with her phone, photographing a house she had no connection to, taking pictures of something she wanted but didn't own, presumably convinced she had a plan for getting it. There's a particular kind of presumption that develops when someone watches you absorb damage, and concludes from that, incorrectly, that you will absorb whatever they choose to deliver next. Kyle had operated on that assumption since the birthday party. His mother appeared to be working from the same playbook. That evening, Tina Pavlovska emailed me a preliminary note. The full report would take another week, she explained, but she'd identified something in the public data she wanted to flag immediately. She'd highlighted it in red in the attached preview document. One line. I opened it on my phone, read it once, read it again, set the phone down on the table, and sat very still. The red line in Tina's preliminary note read as follows. Credit line, revolving $15,000 limit, opened in the name of Sarah M. Fletcher, Regional Bank, previous year. Correspondence address and contact phone on file. Kyle J. Fletcher. Current balance drawn, $14,200. I read it a third time to make sure I wasn't misreading it. Sarah had a credit line I was virtually certain she didn't know existed. It had been opened in her name, meaning her social security number, her credit history, her legal liability. But all the communications went to Kyle's contact information. He would have received the account confirmation, the statements, any alerts. Sarah would have seen nothing, because nothing was directed to her. The $14,200 drawn from that line was sitting somewhere in Kyle's financial picture as spending money, and when the balance eventually came due, it would land on Sarah's credit report, not his. I called Garza the next morning. Can a husband open a credit line in his wife's name without her knowledge? I asked. He didn't answer immediately. Technically, no. The account holder has to provide consent. Identity verification, a signature. Legally, it requires her participation. And practically, i.e., if someone has access to their spouse's personal information, their social security number, their date of birth, and their phone for the verification text, it's been done. The bank sends a confirmation to the contact number on file. If that number is his, she never sees it. A pause. You're describing something that could constitute financial fraud within a marriage, depending on how it was executed, potentially identity theft. What do I do with it? Nothing yet. If you go to Sarah now without the full documentation, Kyle has time to move money, close accounts, create alternative explanations. You need the complete picture first. He was quiet for a moment. Order the full report from your analyst. Get everything documented. Then we decide how to use it. I called Tina Pavlovska that same afternoon and authorized the full report, an additional $1,400, on top of the initial $900. She estimated 10 days for completion. 10 days. I went back to the workshop, started a new project, a small side table, cherry wood, simple lines, something to do with my hands while the rest of it assembled itself around me. 3 days into those 10, Kyle called. Not a text this time, An actual phone call, which was unusual enough that I almost didn't answer. But I did because I wanted to hear the tone. His voice, when he spoke, had shed most of its edge. What replaced it was something carefully constructed, the vocal equivalent of a man in a business meeting who wants to seem reasonable. Walter, I think we've gotten off on the wrong foot here. I'd like to meet in person. No lawyers, no paperwork. Just two people who care about Sarah and Lily working something out. I listened to the full pitch without interrupting. He had clearly practiced it. The phrasing was smooth. The appeal to shared concern for Sarah and Lily was well placed. And the no lawyers stipulation was, of course, precisely the part that was most designed to benefit him. That's reasonable, I said. Where did you have in mind? He suggested a restaurant downtown. I countered with the 404 Kitchen on 4th Avenue, a place I knew and had chosen deliberately. Well lit, usually a moderate lunch crowd, the kind of setting where neither of us would be tempted to raise our voice. We settled on the following Tuesday at 11 in the morning. After I hung up, I called Garza and told him about the meeting. Don't go without preparation, he said immediately. What kind of preparation? He's not calling to reconcile. He's calling because something has shifted and he wants to read your position. He'll come with either a new demand or an offer that looks like a compromise but costs you something real. A brief pause. What's the status of Tina's report? 6 more days? That's tight. He thought for a moment. If the full report isn't ready before Tuesday, use the preliminary data you already have. The credit line. You have enough to put him on the back foot. Don't show everything, but show enough that he understands you've been doing your homework. I spent the following days finishing the side table. Cherry wood moves differently from oak. It's denser, takes more precision, less forgiving of small errors. I worked slowly and got it right. By the time Tuesday arrived, the table was done, and I had reread Tina's preliminary report 4 times. I knew every number in it cold. The full report arrived via email the morning of the meeting. I read it over coffee, starting from page 1. Tina had done thorough work. 16 pages, public data only, with 3 appendices. The credit line on Sarah's name was documented with supporting records from public filings. 2 additional items I hadn't known about. A personal loan of $9,300 taken out in Kyle's name 11 months ago from a consumer lending company, not a bank, with an interest rate of 24.9%. And a second collection notice, more recent than the 2 I'd already found, this one for $3,100, owed to a Nashville area moving company from the previous spring. A moving company. Kyle and Sarah hadn't moved, which meant the debt was from something else, or someone else's move that Kyle had somehow absorbed into his obligations. I printed the relevant pages, folded them into an envelope, and drove to the 404 Kitchen. Kyle was 9 minutes late. I was already seated when he walked in. Corner table facing the door, coffee in front of me. He came through wearing a charcoal suit and a specific kind of smile, the one that's constructed to project confidence, but requires visible effort to hold in place. He shook my hand, firm, the practiced grip of a man who has been told that handshakes matter, and settled into the chair across from me as though he were the one who'd chosen the location. Walter, he said it with the warmth he'd been using on the phone. I appreciate you coming. Of course, I said. The server came. We ordered coffee. His was a specialty drink with several modifiers, the kind of thing that costs $8 and takes 3 minutes to describe. And Kyle spent the opening minutes talking about Lily, how much she'd grown, how smart she was, how Sarah was doing well. He delivered all of it with the smooth competence of someone who understood that the opening of a negotiation is about establishing goodwill, and was putting that principle to work. I let him run through it. There was no reason to stop him. He was showing me his opening position, and it was useful information. Then he reached into the inside pocket of his jacket and produced a white envelope. He set it on the table between us without ceremony. I had my attorney put something together, he said. It's a formal request, but the spirit of it is really just, let's find a clean way to settle this and move forward as a family. I picked up the envelope, opened it, read the 2-page document inside. It was a demand for $12,000, framed as compensation for emotional distress and reputational harm resulting from the unauthorized disclosure of private financial information to third parties. The third parties were apparently Tina Pavlovska and Raymond Garza. The unauthorized disclosure was, as best I could interpret the legal language, my having discussed my son-in-law's public court records with professionals I had hired. Kyle had just claimed that I owed him money for looking at public documents. I folded the pages back into the envelope, set it on the table, said, "Interesting." Then I took my envelope from my jacket pocket and placed it in front of him. He looked at it without moving for a moment, and in that moment I watched something shift in his expression. The first small fracture in the constructed confidence. He picked it up, opened it. I had printed 4 pages from Tina's report. The credit line opened in Sarah's name. $15,000 limit, $14,200 drawn. All correspondence routed to Kyle's contact information. The account opening date. The address for statements. The current outstanding balance. Kyle's eyes moved across the page. His jaw didn't drop. He was too practiced for that. But the color in his face did something interesting. It didn't drain exactly. It settled, the way a face does when the muscles underneath stop performing and just hold position. "Does Sarah know about this account?" I asked. He looked up. The smile was gone. What replaced it was something I'd only seen once or twice from him before. The unguarded version, the one without the presentation layer. His eyes moved briefly to the window, then back to me, calculating. "That's a private family matter," he said. His voice was steady, but the register had dropped half a note. "Between Sarah and me." "Sarah is my daughter," I said, "which makes her private family matters relevant to me." I kept my voice as level as the table between us. "The account is in her name. The debt is in her name. When it comes due, it lands on her credit history. She signed documents she apparently didn't fully understand, because all the confirmations went to your phone." I paused. "I'm not asking you to explain it to me. I'm asking whether she knows." The silence that followed lasted about 4 seconds. In a quiet restaurant at 11 in the morning, 4 seconds of silence is noticeable. "This conversation is over," Kyle said. He stood up, buttoning his jacket with the particular controlled deliberateness of someone who wants to look like they're choosing to leave rather than fleeing. His coffee, the $8 specialty drink, was still on the table, barely touched. I remained seated. "I paid for my coffee," I said pleasantly. "Yours is on you." He left without responding. I watched him walk out through the front door and turn left onto 4th Avenue without looking back through the glass. I sat with my coffee for another few minutes. The server came by and I ordered a second cup. Outside, the street moved the way streets do. Indifferent, continuous, unbothered by the things people do to each other in the buildings along its edges. I thought about Kyle walking to wherever he'd parked his car with Tina's 4 printed pages in his jacket pocket, understanding for the first time that I had not been sitting quietly, waiting for him to decide what happened next. That evening my phone rang. Not Kyle, Sarah. Her voice, when I picked up, had a quality I hadn't heard from her in a long time. Stripped of the careful management, the practiced lightness, raw in the specific way that voices get when something is broken through the surface. "Dad," a pause. "What is that credit account?" I said. "Where are you right now?" "Home. He's not here." "I'll come over tomorrow morning," I said. "I have a full report. I'll explain everything." Another pause, then very quietly. "Okay." I set the phone down on the kitchen counter and stood there for a moment. Through the window, the workshop light was still on from earlier. The cherry side table was finished, sitting on the bench where I'd left it. Clean lines, smooth surface, exactly what it was supposed to be. I turned off the kitchen light and went to bed. Sarah opened the door before I knocked. She must have seen my car pull onto Carruthers Parkway from the window. She was in the clothes she'd probably slept in, or not slept in, with her hair pulled back and a particular stillness in her face that I recognized as the look people get when they've been awake for hours holding themselves together. She stepped back to let me in without a word. The townhouse was quiet. A diaper bag sat by the couch. A half-finished cup of coffee was on the kitchen counter. In the back bedroom, faint sounds told me Lily was awake, but occupied. The specific small noises of a 14-month-old who has found something interesting on the floor. We sat at the kitchen table. I set the envelope in front of her, not the 4-page excerpt I'd shown Kyle. The full report, 16 pages, every document Tina had compiled, every public record, every number cross-referenced and sourced. "Take your time," I said. Sarah read. She didn't skim. She turned each page deliberately, and I could watch the sequence of the information land. The civil judgment, the collection accounts, the personal loan at 24.9% interest, the moving company debt that had no obvious explanation. When she reached the section on the credit line, she stopped, read it again, placed one hand flat on the table. "I did sign something," she said. Her voice was careful, controlled in the way of someone measuring their words against what they can actually afford to say. "He said it was for refinancing our car. The interest rate was too high," he said, "and he'd found a better option through the bank. He had the form ready. He said it was standard." She stopped. I didn't read it. I trusted him. I didn't say anything. He said the statements would come online, that he'd set up the account and manage it. I never saw a statement." She closed her eyes briefly. $14,200. "Drawn in 7 separate transactions over 11 months, I said. "The account is in your name. The liability is yours unless you formally dispute the opening process." She looked at me across the table. The same look she'd given me when she was 9 years old and had broken a window in the backyard with a baseball and was trying to decide whether to tell me. Back then the answer had been obvious. This time it took her a moment longer. "What do I do?" she asked. "You go to an attorney, not mine, your own, and you tell them exactly what you told me, that you signed a document you were told was for car refinancing, that you never received account statements, and that the contact information on file was not yours. The bank has a dispute process for exactly this kind of situation." I paused. "Separately, your attorney can advise you on your broader options. I'm not the right person to do that. I'm your father." She nodded, a small nod, the kind that means a decision is forming rather than already made. "I'll find someone," she said. The following morning she did. I don't know who referred her. She handled it herself, which was the point. She came back from the consultation and called me that evening, voice steadier than it had been the day before. She'd filed a formal dispute with the bank regarding the credit line. Her attorney had advised her on several additional steps. I didn't ask for the details. It wasn't my matter to manage. Kyle came home that afternoon to a house where something had changed, in ways he apparently hadn't anticipated. According to what Sarah told me later, he walked in, read the room, and within 10 minutes was on the phone with Diana. His mother arrived that evening. They sat in the living room together for over an hour. Sarah stayed in the kitchen with Lily. 2 days later, Garza called me. "Kyle Fletcher filed a civil suit yesterday," he said. "Williamson County Circuit Court. The claim is $50,000 in damages for intentional interference with marital relations and emotional harm." I sat down. "He's arguing that your actions, hiring the investigator, commissioning the financial analysis, sharing information with Sarah, constituted deliberate interference in his marriage, and that as a result he has suffered financial harm and emotional distress." "He's suing me," I said, "for telling my daughter the truth about her own finances." "Essentially." Garza's voice had the dry quality it acquired when he was already 3 steps ahead of a problem. "The intentional interference tort is real in Tennessee, but it applies to business relationships, not marriages. Courts have been very reluctant to extend it to family situations. His attorney either knows this and is hoping to intimidate you, or doesn't know it and filed in earnest." A brief pause. "Either way, $50,000 takes it above General Sessions Court. It goes to Circuit Court, which means a full hearing, which means discovery." Another pause, heavier. "Discovery is not going to be comfortable for Kyle Fletcher." I listened to that last sentence twice in my mind. "What do we need to do?" I asked. "Meet with me this week. Bring everything, the Davenport report, Tina's full analysis, every screenshot, every document. We're going to build a response that makes filing this lawsuit the worst decision Kyle Fletcher has made in a year that has not been short of competition for that title." I said I'd be there Thursday morning. After I hung up, I sat in the workshop for a long time without picking up any tools. The cherry side table sat in the corner, finished. Outside, the November light was doing what it does in Tennessee. thin and particular, the kind that makes everything look like it's about to become something else. Kyle had sued me for not giving him $20,000. I almost smiled. The hearing was set for a Wednesday, roughly 3 months after Kyle had filed. The courtroom in Williamson County Circuit Court was smaller than television would have you expect. Wood paneling, fluorescent lights, the particular formality of a room where decisions get made by a stranger in a black robe. Kyle and his attorney sat at one table. Garza and I sat at the other. Kyle wore a suit I didn't recognize, newer than the charcoal one from the 404 kitchen. He was doing the composed professional thing, and he was doing it convincingly enough. I had seen his face go pale in a restaurant when I put 4 pages in front of him. I was patient. Kyle's attorney opened by describing me as a controlling and manipulative father-in-law who had waged a campaign of harassment against his client out of wounded pride after being excluded from a family birthday party. He used the phrase systematic interference 4 times. He suggested that my hiring of investigators and financial analysts constituted stalking-adjacent behavior, and that my discussions with Sarah had been designed to destroy the marriage. He was a capable attorney, and he built the framing carefully. From a distance, it might have looked like something. Garza waited. He had everything organized in a single binder. When his turn came, he walked to the clerk's table without preamble and submitted the exhibits. The $43,800 civil judgment, public record, case 2023-CV-1847 unsatisfied, 2 collection accounts totaling $10,850, a $9,300 personal loan at 24.9% interest, Tina's 16-page financial analysis, all sources documented, the credit line in Sarah's name, $14,200 drawn, correspondence routed to Kyle's phone, with Sarah's bank dispute attached. The Davenport report, Diana Fletcher photographed twice on my public sidewalk, timestamps and plates visible. And the screenshot, Kyle's text to my phone number. Old man, don't make a mistake you can't undo. He set the binder before the judge and said, the plaintiff claims the defendant caused him financial harm. We'd invite the court to review what was actually happening to the plaintiff's finances before, during, and after the period in question. The judge was a woman in her late 50s with reading glasses and the expression of someone who had presided over enough civil cases to know exactly when she was looking at a waste of her courtroom. She picked up the binder. She read, not quickly. Kyle's attorney leaned over and said something to his client in a low voice. Kyle nodded once. His composure was intact, I'll give him that much. But his hands, folded on the table in front of him, had gone very still. Not the stillness of a calm man. The stillness of a man who is concentrating very hard on not moving. The judge looked up from the binder. She looked at Kyle's table. Counsel, your client's complaint states that the defendant caused financial harm through interference. Can you help me understand the mechanism by which a father discussing public court records with his adult daughter constitutes a cognizable tort in Tennessee? Kyle's attorney stood and offered his response. The intentional nature of the conduct, the marital breakdown, the emotional distress. He was professional. He made the best argument the facts allowed. The judge looked at Kyle directly when he finished. Mr. Fletcher, your complaint claims $50,000 in damages, in part because the defendant declined to transfer $20,000 upon request. A brief pause. You're claiming that not receiving a gift constitutes financial harm? The room was quiet. Motion denied. Plaintiff's complaint fails to state a claim upon which relief can be granted under Tennessee law. Court costs assessed to the plaintiff, $3,200. Kyle stared at the table in front of him with the expression of a man who has just run a calculation and arrived at a number he didn't expect. Outside the courthouse, Garza and I stood on the steps for a moment in the cold air. He shook my hand and said the paperwork would be filed within a week. I drove home. A week later, on a Friday morning, Sarah called. The divorce filing went through, she said. I wanted you to hear it from me. I asked how she was doing. She said she was doing okay, not fine, not great, but okay, which was honest and more than I'd hoped for. Lily was good. She'd taken a few steps on her own the previous Thursday. She'd apparently found a particular enthusiasm for the texture of carpet. "Dad," she said, "can Lily and I come over this weekend?" "I have something in the workshop for her," I said. "I just need to finish one piece." I'd started it 3 weeks earlier, when I'd known the case was going to resolve the way it resolved. Not from certainty, but from the kind of confidence that comes from having done the preparation and trusted the process. Cherry wood, like the side table. Small, sturdy, proportioned for a child just learning to climb. A little chair, sanded smooth on every edge, no splinters anywhere. They arrived on a Saturday morning, the first weekend of March. Sarah carried Lily up the front path, bundled in a yellow coat against the cold, already twisting to get down, already interested in everything. I held the door open. Lily crossed the threshold of 2318 Ridgecrest Lane for the first time in her life, sat down on her feet, and took 3 steps toward the workshop door, which was open. She stopped at the entrance, looking in at the sawdust and tools and the smell of wood and finish, and reached down and picked up a curl of cherry shaving from the floor. She held it up and looked at me with the complete seriousness of a 14-month-old examining something important. "That's for you," I told her. If you liked this story, please like this video, subscribe to the channel, and share your impressions of this story in the comments. To listen to the next story, click on the box on the left. Thank you for watching.